Welcome to the webinar. My name is Melissa Roberts. I'm the Admin Director for the Tennessee Self-Storage Association. I want to thank you for joining us today for this free webinar event. TNSSA and Servicemembers Civil Relief Act Centralized Verification Service have come together to bring you this live webinar discussing the Servicemembers Civil Relief Act and how it impacts your self-storage facility. I'd like to go ahead and welcome our speaker for today, Mr. Roy Kaufmann. Roy is an attorney with over 30 years of experience in civil and criminal law, who is conversant in legislative as well as litigation matters. His experience gives him good perspective of the preparations needed for effective prosecution of debt recovery while keeping a very watchful eye on protecting the many rights afforded to individuals under the Servicemembers Civil Relief Act, or SCRA. He is the publisher of SCRA.com, where he has penned hundreds of articles designed to help business owners both understand as well as stay in compliance with the Servicemembers Civil Relief Act. Roy, I'm going to go ahead and turn this over to you now.
Thank you, and thank you to all of you for tuning in to today's webinar. My name again is Roy Kaufmann, and I'm with the Servicemembers Civil Relief Act Centralized Verification Service, which is certainly a mouthful. And our sole function is to respond to inquiries as to whether a person is or is not in active military service. The Servicemembers Civil Relief Act is a federal statute, and it therefore applies to all states. So, as I mentioned, it is a federal law. It's applicable to all states, all federal jurisdictions such as Puerto Rico, Guam, etc. And its goal is really to protect service members while they are protecting our country. The underlying theory was to take away the worry of a service member about things that may be happening on the home front while he may be abroad. There are certain categories of people who are protected, which we'll go into in just a few minutes. But for the purposes of today's discussion, we'll be talking mostly about real active duty personnel and National Guard service. The text of the law, if anybody wants to read it, is at this website, militarywerification.com. Now, this federal Servicemembers Civil Relief Act is, as I mentioned, a federal statute, but it may not be the only law that is applicable. For example, certain states have passed their own versions of the Servicemembers Civil Relief Act. Now, that is an overlay. Those kind of statutes are in addition to the protections under the federal statute. So, for example, certain states may have passed laws that say that service members don't have to pay parking tickets, things along those lines on a more local level. Tennessee, for example, has a certain provision that allows SCRA-type protections to National Guard members that go beyond what the protections are under the federal law, and I'll go into that a little bit later when we talk about Tennessee-specific statutes. So again, if there are people listening to this webinar from other states, it is important to find out whether your own state has its own version of the Servicemembers Civil Relief Act. Now let's talk about what the normal storage facility operators have at their disposal. What is in their toolkit apart from the SCRA? Disregarding for a moment. We know that most states allow storage operators to deny access and sell the contents if there is no payment. Let's go to summary process, go over farther to the right, that it usually allows auctions without having to go to court. And it also, in Tennessee, for example, there's a statutory lien, which basically says that if a storage operator is not paid for storage, then the unit renter cannot just go about selling his property that might be in the unit, because that property is subject to the lien that the storage facility operator has by virtue of the unpaid rent. Going back to that second item that says approach, everything we say here has to be taken with a little bit of salt, in that public relations is a very important part of storage operators' responsibility, especially if the storage facilities are near military bases. So every time you think to yourself, well, does the law permit me to do this or does the law permit me to do that? Keep in mind that there are situations where bad press can really override the legal concerns. Tennessee, for example, has a statute, let's see what it is, says that No enforcement act. This is a specific statute just to Tennessee. And again, this is just the straightforward law, not taking the Servicemembers Civil Relief Act into account. And you'll see in Tennessee, it says that you can't do anything against your tenant unless the default has gone longer than 30 days. And if there are defaults after that 30 days, then it outlines a certain things that the operator can do. For example, selling at auction, things along those lines. And again, at the end, we will be supplying you with links so that you can go directly to the state statute and take a look at what the specific rights are. I assume that everybody has local counsel in your own area to advise you about not only the implications of the Servicemembers Civil Relief Act, but also what local laws you have to comply with. And we have gone to the effort of giving you that local law here at that cj.mp site at the end. Keep in mind, though, that the whole point of this exercise is to understand that the tenant may not be a deadbeat if he has not paid. It may be a possibility that he is deployed, and that's the whole purpose of the Servicemembers Civil Relief Act. Who does the SCRA protect? The SCRA protects active duty personnel. That includes Army, Navy, the Marines, but also protects people who may be commissioned officers in the Public Health Service and NOAA, the National Oceanic and Atmospheric Administration. There are additional categories of people who are protected, as the first slide there said, wounded veterans, also National Guardsmen, but only National Guardsmen who are called up by the President in a national emergency. And this is the distinction I was alluding to before. Tennessee says that the SCRA also protects National Guardsmen who may be called up by the governor. So normally, if a National Guardsman is called up by a governor of a state, he is not protected by the Servicemembers Civil Relief Act, and you are not forbidden from going after his possessions in the event of a default. But Tennessee, like many states, extends the benefit to include people who are called up by the governor. Certain protections also extend after the person has left military service. Most protections end 90 days after the termination of military service. When you request verification of military service, we will tell you what the date is of termination up to 1 year after termination. That way you can do your math. So if you get a report from us that says that the person has left military service on January 1 and you are in the middle of February or so, that person is still enjoying the protections of SCRA, Servicemembers Civil Relief Act. It is not until the third month, 90 days have expired, that the protections expire. So therefore, it is very important to look carefully at our verification and don't just rely on the yes/no. We will tell you, no, the person is not on active military duty, but that his termination date was a recent date. If it ever becomes relevant, SCRA verifications only are effective as a particular moment of time. You will tell us what that date is. Usually people say, what is his military status as of today? But there are rare circumstances where you want to know if what his status was years ago. You can do that. You can give us a preceding date and we can tell you what the status was on that particular date. And since we look back 1 year, if you want to cover a span of time, you can easily place 3 or 4 requests, each with a date in the year that you're looking for, and cover a span of time. But otherwise, you are only getting a snapshot report, which is 99% of the time what people ask for.
Okay, Roy, I do have a couple questions that have come in if you want to stop and answer these.
Sure, absolutely.
How do we verify that they are in the military? I've had some that will check the box and not actually be in service. So I'm guessing they've probably checked the box saying that they're in the military in hopes of maybe having a military discount. So it looks like we've got an issue of having to weed through the ones that are actually in and not.
Well, the verification process that has to be taken usually involves contacting us online at our website is servicememberscivilreliefact.com, and a shorthand is SCRA.com. And there is a registration process which is very quick, and you would be submitting certain information about the individual who you want to check on, and that we would do the research and we would reply. And your reply would be in the form of an email always. You will always get an email reply, but you can also request an affidavit, which we'll again discuss a little bit later, which is a raised, sealed, notarized document from us indicating whether the Department of Defense documents indicate whether the person is or is not on active military duty. You just should not be relying upon any communications from or any assurances from the person himself. You should be independently verifying, doing your own due diligence through the site of whether the person is or is not on active military service. Does that answer the question?
I believe it does. And then from the previous slide, we had a question, do we have to wait 30 days before charging a late fee?
I'm not an expert on the local law, and that would be determined by Tennessee law. All I'm really familiar with is the Servicemembers Civil Relief Act, and the Servicemembers Civil Relief Act would not hold people responsible for late fees during the course of active duty. So
we could apply them to their account. They just may not be held liable for it in the event that they are active duty.
Exactly right. We will certainly go into the situations where a person is on active duty, what you can and what you cannot do.
Okay.
Okay. All right. Let's go on to dependents. The short answer is that a dependent of an active duty service member will only get SCRA protection if that person goes to court. A person who says that she is the spouse of a service member or the child of a service member, those people do not enjoy automatic protections. They have to go to court. And they may get the protections when they go to court, but you would want to see a court order extending those protections to that person. There is a particular section of the Servicemembers Civil Relief Act that deals with storage liens. So you can tell that this was foremost in the minds of the legislators when they considered a legislation. And let's read that together. That the person holding a lien on the property or effects of a service member may not, for 90 days after the termination of service, foreclose or enforce any lien on such property without a court order granted before foreclosure or enforcement. Clearly stated, you may do nothing. If a person is a service member or if a person is within 90 days after leaving active duty, you may do nothing about attaching the property, double locking the locker, selling the property, auctioning the property. You may do nothing to what they say distrain, to prevent a person from getting access to his materials. You may not revoke the card privileges if you have a card-operated entry system. You may do nothing. It is always safer to go first and get your court order. It is certainly not the preferable way to go as far as day-to-day management, but to avoid problems, you should always get a court order, and that is probably through your local lawyer, or if you're comfortable enough in the court system and you want to appeal yourself, which is what's called a pro se litigant, you can certainly do that. During the course of that lawsuit, you will need a Servicemembers Civil Relief Act verification in order to evidence whether the person is in the military or not. And there are certain other criteria which the judge can consider. The judge can also, by the way, modify the contract terms if he wants. So there are tremendous rights that the judge enjoys if the person is enjoying the protections of the Servicemembers Civil Relief Act. And this goes into some of the powers of the judge that I was just telling you. He can, for example, he could just stay the proceedings. He could delay everything. He could delay your request for access to the unit. He could delay your request to sell the property. until he is satisfied that the service member has had an opportunity to participate in the proceedings. And as I mentioned before, he has the right, the judge has the right to adjust the obligation to preserve the interests of all parties. Now, your guess is as good as mine as to what that means, but the judge could, for example, say, well, I'm not going to allow the late fees. The judge could say, I'm going to allow you to sell the property and pay off the late fees and anything extra you pay to the service member, but that's probably not any different than the situation would be in any kind of a foreclosure or a sale. It just so happens that usually when you sell the contents of a storage locker, it's barely enough to satisfy the arrearage that's due on the lease. But in this particular case, the judge could, for example, determine that the lease amount was too high if he thinks that is in the interest of the parties. And parties is plural. Okay, that means that includes the storage locker operator that is a party before the judge. It's not a one-sided determination because parties here is plural. There's a problem here if you don't abide by the Servicemembers Civil Relief Act. There are criminal penalties that could happen, and there are fines that could happen. It is a very, very serious statute. And one matter I'd like to make sure we all understand is the participants in this webinar may be the owners of the facilities, may be the higher end managers, but it is very important that the people on the front line at the facilities, the day-to-day managers, understand the Servicemembers Civil Relief Act and understand the dangers of not following the procedures that you set down for them to follow.
Another question has come up from the slide that you just went over. Do we have to wait 30 days before charging a late fee? And are we not allowed to have any access to the property at all if they're in the military?
I think we addressed the late fees. The late fees, you can assess the late fees. There's nothing in it that says that you can't assess them. Whether you're going to get them or not is a totally different question. But you may not prevent access to the unit for anybody that is in the military or 90 days after their termination date. You may not prevent access. They are to have access to their lockers unless you go to the court and get an order that says otherwise. There's no flexibility.
Okay.
We were talking about the ramifications of the problems of not complying with SCRA. There are many lawsuits around, some with various degrees of notoriety in newspapers, Department of Justice taking action against storage companies who sell belongings without following the rules, without going to a court and getting a court order. Here, I've just given you a quick little blurb about one of those situations. The costs in not complying with SCRA can be staggering, not to mention the public relations disaster if this happens. Here we have a situation where the criminal penalties were assessed against a storage operator who really blatantly and seems to have had full knowledge went ahead and sold the property of an active duty military person. And these things are easily available on Google to people who are looking for a facility to put their belongings in, and it certainly is something you're going to want to avoid. And if you're not aware of these cases, then you are now. So what can you and your frontline people do to make sure that you do comply with the SCRA? And we would submit to you that these solutions are so easy, they're fast, they're inexpensive. Make sure you educate your staff. Make sure you have checklists, and a checklist that your staff uses to intake a tenant and a checklist to use when there is a default. We would suggest that in your tenant applications that you include certain information. First, make sure that you have the full name of your tenant. Try to include a middle name or initial. The reason why we want these kind of details is as follows. When you want to do a military verification, if you do not have the Social Security number, we need information to find the person because we, the SCRA CVS, our organization, needs to find the Social Security number. That's our task because the Department of Defense indexes only by Social Security number. So if you make our task easier to find the Social Security number, that is what makes the likelihood of you getting a true, accurate military verification more likely. So many storage facilities don't like keeping Social Security numbers. If you do keep Social Security numbers, I would suggest that you do not put them in any computer. You would keep them in a locked file cabinet with very, very limited access. And for the reasons that you can also anticipate, any kind of an accidental release of Social Security numbers is a totally different and very serious issue. So these storage facility operators who elect not to keep Social Security numbers then would want to follow these suggestions that we're outlining here. Give us the name, including middle names of your tenant. Take a few different phone numbers. Phone numbers are very good for us for finding Social Security numbers. Get the names of nearest relatives. You can always say you need these people to have the ability to notify them in the event that there's something wrong at the storage facility or that you need an emergency contact, and if the person's not available, who can they recommend that you contact? Because our databases often have a correlation between people and their relatives. And again, we use this information to try to find the Social Security number. It is not improper, and in fact, it is a good idea to ask right on the application whether the person is on active military duty and their start date. And the last thing is we do want to make sure that you have a very secure method of storing your applications. If your applications have a Social Security number, as I said, you should not be routinely scanning Social Security numbers or anything into any electronic format to avoid the possibility that the Social Security numbers would get revealed to third parties. People have asked me about a waiver. Can a person waive their rights under the Servicemembers Civil Relief Act? And the answer is yes. Waivers are permitted under certain circumstances. However, first, I will tell you that many storage operators, especially those near military bases, decide as a matter of policy not to use waivers. It may leave a bad taste in people's mouths when a document is presented to them saying that their military service is not important enough to take into consideration, especially if a large portion of the storage facility's customers are service members because of the proximity to military bases. Again, as a public relations aspect, you may not want to use waivers. But if you do, please understand that waivers are only valid if they're signed after a person is in active military duty. You cannot waive your rights under the SCRA before you've reported for active duty. Other requirements of the waiver are that the type must be in writing. It must be in writing. It can't be oral. This waiver has to be in writing. It has to be in a specific font size. That's a type size that is larger than 12-point font. It has to be on its own. It has to be a separate document, a separate piece of paper. You cannot include this waiver in your lease. It cannot be buried in any document. It has to be all on its own. And finally, it has to be very specific. It has to reference the obligation that the person is waiving. For example, the description of the lease. So here I have drafted a sample waiver for your consideration. And here in the regarding line, you'll see the specific elements of the obligation that the people are referencing. So it is a very specific lease. It is for a very specific unit number, who the tenant is, things along those lines. It has to very clearly state that I, as the service member, am waiving my rights under the Servicemembers Civil Relief Act, in which event in which event you can proceed as if the person were not under the protections of the Act. And at the end of that letter, you'll also see a link that we have for considerations that you might want to take into account involving waivers. Before, I mentioned that it was very important to do checklists. I think that the checklist could include a default letter. The SCRA does not preclude default letters. You can certainly send out default letters. And obviously, before you're taking any action to enforce a lien or to lock out a person, you've got to make sure that the person is or is not on active military duty. And that only after you're sure, positive, that the person is not in the military, then do you take advantage of those provisions like we saw earlier that Tennessee has, which allows certain kind of actions to be taken after 30 days of default.
Roy,
so there are some questions.
Yeah, just to clarify, there is a couple questions coming up, specifically about the not being able to overlock the unit, because typically we overlock around day 6 if they're past due, obviously to prevent the person from moving out and skipping out on that month's rent. So are you saying that we would need to, at that point, go through the entire process and verify that they haven't since joined active status?
Absolutely. Unfortunately, but absolutely yes. And again, remember, this verification process is easy. It takes, I would say, no more than 5 minutes. So the person who's charged with putting the double lock on the unit should first run the verification to see if you've got any issues that involve the SCRA. The SCRA was very clear in that the statute that I cited earlier, that the storage operator is prohibited from doing that. I will also mention to you that I heard from another state storage facility owners organization that counsel there had said that he didn't read this to prohibit double locking. He didn't read the statute the way I read it. Mm-hmm. My response to that is that I think the statute is pretty clear, but why risk it? Why risk the kind of negative publicity and the kind of lawsuits that we talked about that can happen if you are found to be in the wrong, when the verification process is so easy? It's not expensive. It's quick. It's easy, and it's, to me, it's very clearly required under the law. Remember, we also have criminal penalties here. We don't just have civil penalties. We don't just have fines. We could have a criminal prosecution. Rare. It's going to be rare. It's only going to happen if there's absolutely the most egregious situation. But certainly, it is out there. And I see that one of the members has asked, you cannot deny access, does that mean they can move out? Unfortunately, that does seem to me to be the answer. I don't think the SCRA has any alternative. That if you want to double lock a unit and you find that the person is in the military, you better go to court first and get a court order to do that. And you might as well start with your local lawyer to find out what the process is, so that when the situation presents itself, you're not in a learning curve, and that you have your documents ready to go to see if you can beat them.
Go ahead. The very next question said that it addresses our lease, which you and I spoke about earlier. That our lease states that if there's any information change whatsoever, that it's the responsibility of the tenant to notify us of that change. That includes, military status. So does that not cover us in any way?
The statute does not shift the burden to the service member to provide notifications. The statute is clear that the onus rests with the storage facility operator to determine military status. It would be nice if they did, but there is no requirement on the service member side. The requirement is fully on the storage operator to know that before he double locks, before he has any kind of an action to sell at foreclosure or auction, that he determine the military status, and if the military status is positive, as an active duty member, nothing at all be done until a court order is obtained. The court order is what protects you. If you do anything without the court order, you run the risk of having violated the statute. Let's just see, there's one other thing I say. A message, is it possible for the Tennessee lien laws for self-storage operators to override the federal mandates on issues such as overlocking a late service member? This just doesn't seem correct. I understand not selling their property, but giving them access seems excessive in cases where they are late. And I feel for you, but I will tell you that the state laws are an overlay. They may be in addition to the federal law, but the federal law cannot be amended by a local state statute. So I would assume that when the legislators, when the House and the Senate of the United States voted on the SCRA, they considered these propositions, and they determined that the risk to service members outweighed the risk to storage operators in collecting their past due rentals. Okay, now how to go about determining military status. There are two basic resources that are available to the storage industry. Number one is the Defense Department has what's called the DMDC, and that is one source of information as to whether the person is on military service or not. We would point out that that particular service, which is, by the way, free of charge, does not have affidavits available. If you do not have the Social Security number, they will report to you that they're unable to give you any information. You can run a report with the DMDC if you only have the birth date, but the DMDC report will have a big bolded disclaimer on it, which says you cannot rely upon this report because the only unique identifier that the Defense Department uses is the Social Security number. And it would be of no surprise to know that many judges don't like that kind of a disclaimer on a document presented to them. They're saying, well, if it's not guaranteed, why should I, the judge, accept it? Our service, which is to the right, which is the SCRA CVS, and those URLs are right below it. We can, of course, and our job is to find the Social Security number and the other information. You do have the ability to get affidavits from us, and affidavits are basically notarized documents, as I mentioned before, which basically says that upon due diligence, we have determined that the following is the status of this individual. There are certain rare circumstances where we are unable to run the SCRA verification. That's usually when the person has a very, very common name, no Social Security number has been provided, or that the person may not be a U.S. citizen, or there may be a pseudonym being used. The cost for the military verification is always $36.40. The only surcharge is a $20 charge if you want to get an affidavit. And there's another charge if you want it sent by FedEx. I don't recall what that charge is. But you can track your orders on our site. You can order affidavits after the fact. You can request copies. We also are very, very accessible. You have chat features, you have phone, and obviously you can imagine you're not going to get that kind of accessibility with the Defense Department directly, but we are standing by, and this is all that we do. We know this stuff inside and out, and we have seen the more unusual situations and are certainly happy to answer any questions you might have. A little bit more here about what an affidavit is. It's a notarized document. There is no form that is required under the federal law. They basically just outline certain things that the affidavit has to cover. Some states and counties have their own. As you see to the right, I happen to have seen that the Chancery Court of Shelby County in Tennessee happens to have their own form. But usually we have found that the courts across the country accept what we have as our standard affidavit, which is very detailed. And if you also have to check and see with your local court clerk. Sometimes these local clerks have their own forms. If you want to submit that form to us to put in our library of forms, we'd be very happy to take that on and prepare the affidavit for you. That last point, of course, we've talked about this over and over again. If you find that the person is in the military or has retired within the past 90 days, stop everything and go to court first before you take any action against the tenant. Resources. Obviously, the Tennessee Self-Storage Association is a wonderful resource. Our website, I would submit, is a really excellent resource. There are many, many, many blog articles specifically on the storage industry. It is an industry we work with day in and day out and try to address their very, very specific concerns. And if you go on SCRA.com and click on blog, you can look at those right now, or if you want to wait for your copy of this PowerPoint, you'll be able to see the link that we've printed right there below. We also have a guide for the self-storage industry, very, very specified to that particular industry. And you can load it right now by going to scra.com/free guide, or you can obviously click on the link when you get your copy of the PowerPoint presentation. And again, if you have any questions or anything, I'm happy and available to answer any concerns. And that's all I have for your good listeners, but I'm certainly here to answer any questions that anybody might have.
We had two other questions that were added just a couple minutes ago from Ashley and Brandy, if you want to address those.
Yes. Okay, so the question is, so we have to check every late tenant to make sure they haven't joined the military before we put an overlock on, or do we check only those tenants that have informed us on our lease that they're in the military? $36.40 for every lock I need to put on a lock on. At one location, there could be 70 overlocks. I hate to be the bearer of bad news, but I will tell you that if you overlock a unit and the person is on the military, you could be in violation of the SCRA. And I'm even saying that lighter. You are in violation of the SCRA, and you can be subject to any kind of actions that you could have local people, local prosecutors interested in prosecuting this. You could have organizations that are representing military members who might decide to look around and snoop around and file suit on behalf of a bunch of service members who are subject to overlocking. The answer is that your obligation is to verify military service before you disturb a military member's access to his unit. And again, I'm not here to justify the law. I'm saying to you that when the law was passed, these considerations, I assume, were presented to the Congress, and the Congress weighed it out, and they decided that it is the responsibility of the storage industry to not take action against service members. Keep in mind, there's a very specific statute on storage lockers, on storage facilities. To me, that connotes that they were very aware, that Congress was very aware of it, and they made the conscious decision of saying, no, you may not overlock unless you check military service. You can read the lien language as clearly as I, and I don't think there's much wiggle room there. Melissa, any other?
Okay, yeah, actually I do have a couple more. Is there any obligation from the military person to the self-storage facility?
Well, I'm telling you, nothing here is taking away the obligation to pay rent. We're not talking about obligations. We're talking about whether the storage industry can assert liens or disturb access. The only way that the SCRA could affect the actual duty to pay the storage facility would be if the judge determined that he wanted to readjust the obligations in the interest of the parties. Otherwise, the obligation to pay is not affected at all by the SCRA.
Okay. I have another question about the superior officer. Is it okay to contact the tenant superior officer, and how much detail about their account are we able to provide?
Part of your question goes outside the SCRA because it deals with some privacy issues. If I were going to be contacting a superior officer, I would do so under the context of trying to get word to the service member that there is an issue, and is there anything that can be done to make sure the service member is aware of it. I would be careful about disclosing dollar amounts or anything that might actually violate the service member's privacy. Let's consider an analogous situation. Would you call the employer of a tenant to ask, for assistance in payments or anything along those lines, I think that you should consult with your own lawyers. But I would be worried a little bit about the privacy aspects of asking for that kind of assistance. On the flip side, I will tell you, I have heard of people calling the superiors and getting results, but I think you should be really taking the position that you're really trying to make sure that this issue gets addressed, so as to not, just to not inconvenience or to not deprive the service member of the use of the rights to his property. But that goes a little bit beyond the scope of the SCRA.
Right. We do have a couple more questions coming in. Does this apply for military personnel that are out of the country, or does it apply for stateside as well, or just out of the country? So I guess, in other words, defined active duty for us.
Active duty is defined as within the country. It's defined as when they report for duty. And so they could definitely be stateside and enjoy the protections as SCRA. There's one little exception for guardsmen. Guardsmen who are called up for active duty, they get their protections when they receive their orders, not when they report for duty, but when they receive their orders, they automatically are enjoying those protections. And the verification we give you will give you the date that they start, that those protections start. For example, if you have a person that that's been away a long time in another country or whatever, you've got to go to the court. You've got to go to court, get a court order asking the court for relief to allow you to auction off the material. This is not a complete closed door. All we're saying is that you need the approval of a court to take action to get the same access that you would have gotten under the statute had the person not been under the protections of the SCRA. And that means you certainly have foreclosure, you certainly have auction, you certainly have all the other rights. You just have to go to court first to get the judge's blessing to take advantage of those rights. So you shouldn't be sitting around for a long, long, long time unless you really want to, because the person is in the military. Your recourse, your solution is just simply to go to court, put it in the court's hands and say, this is the situation. We can or we cannot find them, and then let the court decide what you can do. And remember, the word parties is plural there in that statute. Respecting the interest of the parties, that means you're before the court asking the court for help. And it's a situation where you should be lighting the candle and not cursing the darkness, going to court and asking the court's relief that that you be allowed to proceed.
Okay, so that answers, I believe, our last question from Pamela. She said that they have a military personnel who's not paid in 10 years, and basically they've been sitting on the unit. So her next step would be to address the courts and get the proper court documents and move forward with the sale.
Yes. I mean, as I said, you shouldn't just assume that all doors are closed. You have your rights, but you have to go to court to assert them if the person is on active military duty.
Oh, we have another one. If there are fees from going to court to proceed, are we able to then charge the service member the fees that we accumulate through that process?
I suppose there's nothing to stop the court from enforcing a valid lease. If the valid lease says that the defaulting party will pay the non-defaulting party attorney's fees, I would dare say the judge should order that. But that's my own personal opinion. There's nothing in the Act that says that no legal fees shall accrue while the person is in military service. The statute does not go that far.
Right.
The statute just simply says that before you sell somebody's property, you have to ask the court's permission. So I don't think that this is an abrogation. I don't think this is stopping any assessment of attorney's fees, late fees, double the storage fees. I mean, any holdover fees. Whether the judge will agree to them or not is certainly in the judge's discretion, but there's nothing in the statute that stops you from doing that.
Okay, so Pamela has an add-on question. She's the one that's had the service member for the last 10 years that hasn't paid, and for her to proceed, which court does she? What is her next step?
I think you need to contact your local county just to see who is the court that has the jurisdiction over storage facility liens. It may be dependent upon the dollar amount is owed. Certain states have situations where one court will handle a monetary dispute up to, let's say, $5,000, and if it's in excess of $5,000, it's more. Some courts also make you go to the landlord-tenant branch of that particular court because it is a landlord-tenant relationship, perhaps between the facility and the tenant. But you'll have to contact either the local court or the local lawyer to find out which court has jurisdiction over an arrearage due to the service member, and an adjudication as to what the storage operator can do about getting back possession of the storage locker. People go to court every day. Storage operators go to court every day to get possession of the units and to get rid of the belongings in the unit for defaulting service members. People do it. You just have to get it into your system, know the process, so that when it comes up, the people on the front line know what to do, and don't accidentally. For example, if you take the position that you do not want your facility to be double locked on a default until somebody checks the military status, that obviously has to be published to the people before they put the lock on.
If it's a situation where the tenant is consistently late every month, he goes into default, and say he pays on the 20th of each month, but our laws say that we can overlock on the 6th, does that check need to be done every single month?
You know, all I can say is I can feel for you. The statute is very clear that before you distrain, before you interfere with access, you have to make sure that the person is not in the military. You do so at your risk. I mean, all I can say is if people are not satisfied with the law, maybe they should lobby to have it changed. But the law as it stands right now is that you're not allowed to interfere with the access unless you're sure the person is not in the military. And I'm going to try to see if I can go right back up to and there's a question here. Somebody had mentioned also you need the Social Security number. You can't look them up. I will tell you that, that's what we do. So if you don't have the Social Security number, we can certainly help you out there. A person holding a lien on the property, that means a storage operator who has a late tenant, may not, during any period of military service and for 90 days thereafter, foreclose or enforce any lien on such property or effects without a court order granted before the foreclosure or enforcement. The question is whether double locking is an attempt to enforce any lien. My thought is that certainly double locking is an attempt, although a simple attempt, to enforce your lien on the property. And the countering argument that I heard espoused was that it is not an attempt to enforce a lien. And that may be open for discussion, but I certainly would be very, very careful about double locking, because you saw the lawsuits that arise, you saw the negative publicity that can happen. The dangers are great, and this is a $350,000 judgment against the storage operator. Then how much you think the property was worth in that unit? I mean, certainly it was a hell of a lot less than $350,000. The risks are quite immense, and you just have to do a cost-benefit analysis and decide whether it's worth it or not.
Okay. All right. Well, I don't think I've got any more questions that have come in, so it looks like we've addressed everything. I want to thank everybody for joining our webinar. We really appreciate your participation. It was very much appreciated. And this will be emailed out to each of the attendees, and we will also post it on the members only page on the website for future viewing. So, and any additional questions we'll also address at our legal seminar coming up in September. So there's my shameless plug for that one.
All right, and I thank you to all of you for your kind attention. Have a nice afternoon.
Thank you.